Parliamentary Secretary to the Minister of Justice and Attorney General of Canada.
Good afternoon, Madam Speaker, and I'm glad to speak this afternoon, and I will be sharing my time with the member for Aurora, Oak Ridges, Richmond Hill. And let me at the outset acknowledge that we're gathered here on the traditional unceded lands of the Algonquin people. And before I go into the speech, Madam Speaker, I just have some important reflections on the Canadian Charter of Rights and Freedoms. It's a document that actually has entrenched into Canadian law such fundamental rights and freedoms that I think people around the world aspire to achieve. And over the years, this has been a guiding document. In my life, I think it's been a guiding document for many in this country. And while it's not perfect, I think it's offered a very important path towards recognition of human rights, international human rights, and the universality of human rights. And of course, we can date this back to the Universal Declaration of Human Rights that was signed right at the end of World War II, but also the former Bill of Rights in Canada, as well as other international covenants and documents that Canada is party to. On a personal level, Madam Speaker, my family came to Canada 40 years ago this year. We fled an armed conflict in Sri Lanka, one where the rights of minorities were suppressed, and suppressed at will, and oftentimes reinforced by law. And I can tell you, around this House, around this country, around my riding, there are millions of Canadians who can trace their history to difficulties because governments chose to make decisions that would suppress their rights for who they are. And in fact, in Canada itself, we can see a number of occasions, and I know the member for Esquimalt Sandwich Souk talked about the experience of the LGBTQI community, and of course, the member for Winnipeg Centre has often spoken about the disparity between Indigenous and non-Indigenous Canadians. So the Canadian Charter of Rights and Freedoms in many ways has set a benchmark for us to follow. And while it is important that we were able to get this agreement in 1982 with the provinces, with the inclusion of the Notwithstanding clause, it was always meant to be used sparingly by governments. Notre charte est...
Our charter is also a source of inspiration for countries around the world who have drawn on it as they wrote up their own constitutional documents. As a Canadian, I am proud that we decided to create such a legal instrument 40 years ago.
Known as the Notwithstanding Clause, made it possible to reach this political compromise between the different entities that make up Canada when the Charter was adopted. This section authorizes Parliament or the legislature of a province to derogate from certain provisions of the Charter, namely those protecting fundamental freedoms, legal guarantees, and equality rights.
Interrompre l'honorable secrétaire parlementaire, l'honorable député de Shefford, un rappel au règlement.
Désolée d'interrompre le discours.
Sorry to interrupt the speech, but the interpreter says that the member is speaking too close to the microphone and there's a risk of feedback.
Keep the earpiece far from the microphone. Far from the microphone on the desk, yeah. Yeah, or just inside. Yeah, perfect. The Honourable Parliamentary Secretary, thank you.
Madam Speaker, throughout this historical overview, I hope to bring out two main points. First, who used the Notwithstanding Clause in a particular political and historical context. The use of the Notwithstanding Clause was exceptional until very recently, and the other recent case of Ontario where it was preemptively used. The political cost was simply too high to do otherwise. Second, the frequent practice of provincial legislatures was to invoke the notwithstanding clause in response to a court decision. In my opinion, the only potentially legitimate use of recourse to Section 33 necessarily involves the courts. Our constitutional tradition is one marked by dialogue. The preemptive recourse to the derogatory clause eliminating the legal debate is contrary to our traditions and must be decried. The legislature of Quebec, for a time, included a standard notwithstanding provision in each of its new laws, a practice that continued until the 1995 election. Afterwards, the notwithstanding clause was used only a few times by the provincial legislatures. The Saskatchewan legislature passed back-to-work legislation invoking the notwithstanding clause in the mid-1980s. The legislature did this in response to a decision by the Saskatchewan Court of Appeal that declared an earlier version of the law unconstitutional, did not include an overriding provision. The Supreme Court eventually sided with the Saskatchewan legislature. She ultimately concludes that the law did not infringe the charter. Recourse to derogation clause in this case was therefore not necessary. The third province to use the notwithstanding clause was Alberta. In 2000, the Alberta legislature passed the Marriage Amendment Act 2000. With this act, the province's Marriage Act was amended to declare that a marriage could only be between persons of the opposite sex. Madam Speaker, apart from the initial and particular example of Quebec, immediately after the patriation of the Constitution in 1982, it can be seen that recourse to the notwithstanding clause was relatively exceptional. Prior to 2018, only 3 provinces had laws in effect invoking the notwithstanding clause, and only a few times. On the other hand, since 2018, we can only note a renewed interest in the use of this clause. The Ontario legislature almost invoked the notwithstanding clause in 2018 in response to the Ontario Superior Court decision that declared unconstitutional a law reducing the size of the City of Toronto's council. Legislation invoking the notwithstanding clause was not passed, however, due to the intervention of the Ontario Court of Appeal. Subsequently, the Ontario legislature passed for the first time legislation invoking the notwithstanding clause in 2021, the Protecting Elections and Defending Democracy Act of 2021. The notwithstanding provision was invoked here in response to the decision of the Ontario Superior Court, which declared certain provisions relating to third-party election expenses unconstitutional. This new bill from the Legislative Assembly of Ontario, therefore, follows a worrying recent trend. As I mentioned, Madam President, if the use of the derogation clause was then exceptional, then it seems to be less and less the case. One could add to the examples I described to you earlier in this failed attempt by the New Brunswick legislature in 2019. This provision should also not be taken lightly. There was never any question when it was included in the Charter that it would become a tool used routinely. It should only be used in the most pressing cases where no other option could be considered and when there is a strong public policy consideration. What is the point, if not of adopting a Charter incorporating into our Constitution fundamental rights and values, if only to derogate from it at the slightest inconvenience? A healthy democracy should not be based on majority rule. It must respect and protect all Canadians by giving them the chance to question the decisions of the governments in place. The Charter is an instrument for challenging decisions made by governments by applying clear guidelines. It is not normal for a government to be able to make decisions without submitting to the scrupulous evaluation of its population. However, Madam Speaker, this is what Article 33 is for, to avoid any debate and exchange of ideas about a measure. This is a way for the government to hide behind the notwithstanding clause in order to avoid questioning itself. I don't think that allows us to live in a healthy democracy. In addition, the time of use of the notwithstanding clause is also to be considered. Indeed, when used preemptively, preventatively, it has even more negative repercussions on our parliamentary system, since governments can pass laws without worrying about the impact on the fundamental rights of their citizens. Its preventative use risks upsetting the fragile balance that exists between the protection of fundamental rights and the effective functioning of a parliamentary system. Madam Speaker, in closing, I would like to just conclude by saying that I take a dim view of this frequent preemptive use of the non-derogation clause. This practice trivializes our most basic protections, and I'm happy that we have the opportunity to discuss this important matter for all Canadians across this country. Thank you, Madam Speaker.
Ms. Jones.